So good afternoon if you're on the East Coast, and good morning if you're far enough west. I know we've got some friends out in Hawaii listening in today, so good morning to you all. You are listening to Affirmative Action in Higher Education, the impact of SFFA, or Students for Fair Admissions, versus Harvard and UNC, respectively. So this is the webinar where we're talking about these two recent Supreme Court cases relating to affirmative action in higher ed. This is part of the higher education webinar series offered by the law firm Thompson Coburn, LLP. While we are taking a minute here for folks to join, I'll go ahead and get into some of the housekeeping. First of all, you'll see that there is a Q&A widget here as part of the platform. If you have any questions during the webcast, you can submit them through that Q&A widget at the bottom of your screen, and we will do our best to get to some, if not all, of those questions at the end when the formal part of the presentation has been completed. A copy of today's slide deck is available in the resource widget. We're all about the widgets here at Thompson Coburn. We encourage you to download any resources or links that you may find useful there. And you can also find additional answers to some common technical questions and issues located in the Help widget at the bottom of the screen. So if you experience any technical difficulties during the webinar, make sure to take a look there, and you may be able to find a solution quickly. This webinar is CLE accredited, so if you are an attorney looking for continuing legal education, you may be able to get it here. It's CLE accredited in California, Illinois, and Texas for 1 hour of general CLE credit, and in Missouri for 1.2 hours of general CLE credit. The webinar is also CLE accredited in New York for 1 hour of experienced and transition credit. Keep in mind, we award CLE based on attendance for the entire 60 minutes of the webinar. And with that in mind, you will note through the webinar that we will periodically display secret words and a brief multiple choice poll. And the lawyers in the audience will be familiar with this concept. So you will be asked, and please do select the correct secret word at each one of those points in time to ensure that we can give you your credit for CLE. Finally, following the presentation, as always, we have a post-webinar survey. We are truly and deeply grateful to anyone who takes the time to fill those out. I always say this, and it's true, we review those after every single webinar. We take them very seriously, and we try to incorporate your feedback to ensure that the next webinar is better than the one before it. Thompson Coburn, if you're not familiar with us, we are a full-service law firm with offices across the United States and lots of big markets, as you would expect, like a lot of law firms. We have about 400-plus attorneys. We have a higher education practice within our law firm, so we're talking about a group of lawyers who spend all or most of their time serving colleges and universities and career schools and sort of the whole pantheon of post-secondary institutions. And among our core competencies, as you might expect, are federal financial aid and the U.S. Department of Education in its various regulations. My name is Aaron Lacey, and I'm often speaking in these webinars. My sort of core expertise is the U.S. Department of Education and sort of the regulatory framework. So if you've been listening then this year to our webinar series, you've probably heard me talk about the Bar Defense Rule or financial responsibility or other financial aid type issues. But today, I'm just serving as the moderator because we're talking about a Supreme Court decision, and it made sense to us that you should hear from our Supreme Court experts. So our partner, Kraft, who's in our Supreme Court practice, is going to be taking a lot of time to talk to you about these particular decisions and, the nuances that are apparent and prevalent when you're dealing particularly with the Supreme Court. Katie is in our D.C. office, although she has St. Louis roots. And represents clients, as you would expect, before federal courts, administrative bodies, has authored Supreme Court briefs, and provides lots of regulatory and compliance guidance to folks who are dealing with federal-type issues. So, Katie, thank you so much for taking the time to be here with us today, and in particular to sort of provide your perspective as someone who spends a lot of time thinking about the Supreme Court and their decisions. And we're also joined by one of my colleagues in the higher education practice, Stephanie Cohan. Stephanie does a couple of things at our firm, does a lot with our college and university clients, but particularly around labor and employment issues. And so, as you would expect, has a real background in discrimination law and issues that sort of impact different discrimination coming at it from different types of angles. And I'll also just mention for the record that Stephanie has a degree from Harvard University, so one of our respondents in this matter. or that will be discussed today. So this is my last little piece for now, and then I will hand it off first to Stephanie, who's going to give you just a brief history of affirmative action and education and higher education in particular. And we know that a lot of the folks listening in today are in-house counsel and at-large universities and have some background and are probably familiar with some of the sort of historic affirmative action cases in education. Not everybody is. And even for those who have some familiarity, it's important, as you would expect, to have a refresher, because as Katie will then discuss in the next section, where she really focuses on the Harvard and UNC decisions, even in these decisions, the court was referring to some of those historic cases that set some critical precedent. And then in the last section here, we're sort of in three parts today. So the third act, I'm going to put back on the moderator hat, and I'm going to pose three questions to Katie and Stephanie to sort of tee up some conversation in terms of what's next. And then finally, as always, we have a little bit of material here for you about some of our resources that are available. So with that all having been said, again, thank you to everybody for joining us today. And Stephanie, I will turn it over to you to give us a brief history of affirmative action in education.
Thanks, Aaron. As Aaron just mentioned, I know that many of you likely have an understanding of the cases affecting affirmative action. However, in order to provide some context of where we are today, I do just want to go through this brief history. So starting first in 1896 with Plessy versus Ferguson, here the court held that state mandated segregation laws didn't violate the Equal Protection Clause. Here the court ended up using the term separate but equal, which allowed for segregation across much of American life. In 1954, in looking at this separate but equal understanding, in what's probably the most well-known education case, the court in Brown looked at whether segregation in schools violated the Constitution. The court held that separate but equal was unconstitutional and schools must desegregate. However, desegregation was appearing to be very slow, and a year later, the court held that desegregation must occur with all deliberate speed. So then looking specifically at the affirmative action cases, in 1974, this was the first time that the Supreme Court considered race-based admissions policies. While this case was actually dismissed, during the case at the Supreme Court, Justice Douglas signaled that under the Constitution, there was a need for race neutrality in admissions. So in looking at that and considering that, there was a lot of discussion among researchers and those studying the Supreme Court about what that would look like when affirmative action cases did reach the court. And then a few years later, in Bakke, the court held that although the use of quotas in admissions was unconstitutional, the use of race in admissions could be permissible if it was one of several admissions criteria. I think it's also worth noting here that the court actually ordered that the plaintiff be admitted to the school. I think that fact is just interesting in the sense that although the court looked to the fact that race-based admissions could be constitutional, the fact that this quota system was in place at the time allowed for the court to order the plaintiff to actually attend the school. Then looking forward about 25 years or so, there were two cases that came out of the University of Michigan. These cases in Grutter versus Bollinger and Gratz. So in first in Gratz, in looking at undergraduate admissions, here the court held that the policy that was at issue for the undergraduate admissions was unconstitutional because it didn't allow for individual consideration of each applicant. However, in contrast, in Grutter, which occurred at the law school at the University of Michigan, there the law school took a holistic approach to admissions. So it actually admitted that it used race as a factor in making admissions decisions. It also argued, though, that there was a compelling interest in achieving diversity among its student body. And from this case, it's notable that the court held that a narrowly tailored admissions policy that takes into account race as one factor among many, so looking at a holistic view of each applicant, is likely, it would pass constitutional muster, and that moving forward, similar cases might also. Also, it's notable, and we'll discuss this as we talk more about the Harvard and UNC cases, but the issue of whether a time frame for race-based admissions program also arose. In this case, Justice O'Connor reasoned that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. So from that, the question arises, is there a requirement that race-based admissions policies have some kind of deadline in place? In 2013, the court again took up an affirmative action case in Fisher versus the University of Texas. The 2013 case was remanded due to the Court of Appeals not applying the correct strict scrutiny standard. But in 2016, the case came back to the Supreme Court, and the court held that the University of Texas did not violate the Constitution when it used race as a consideration in the admissions process. So that really was just a very brief background of these affirmative action cases and where we are. I am going to hand it over to Katie to talk about the UNC and Harvard decisions. But first we have our first secret word. And today's first secret word is student. So please select the correct word from the list below.
I will.
Again,
definitely.
The word is
I'll
student.
just.
Yes.
Yeah, I'll jump in and I'll just say, when I was a student in my Civ Pro class in law school, my professor, who's now the chancellor at Syracuse, had been previously the dean, a professor at Michigan, and was very active in the Gratz and Gutter cases. So I remember we were actually discussing in the context of our law school class when I was a student, those two cases, affirmative action cases, which were in front of the court. Because I'm an old person. Old people can remember things like that.
That's a cool
At any rate.
That is a cool connection, and really interesting.
Moving right along. Katie, what do you think?
Well, so now we're going to talk about the Harvard and UNC decision, the reason that everybody is here today. So thanks, Stephanie, for giving us the background, how we got to where we are and where we were when these two cases went up to the Supreme Court. So first of all, this decision is two cases. So it's the Students for Fair Admissions versus the Presidents and Fellows of Harvard College. And that same organization also sued in a different lawsuit, the University of North Carolina. So in the Harvard College case, SFFA alleged that Harvard College's admissions process violated Title VI and specifically by discriminating against Asian American applicants. In the UNC case, they challenged the constitutionality of UNC's admissions policies under the Equal Protection Clause of the 14th Amendment of the Constitution. So these two cases were consolidated at the Supreme Court, and the questions presented, the questions that the Supreme Court decided that it would address were first, that whether the court should overrule Grutter and hold that institutions of higher education cannot use race as a factor in admissions. So that relates to the UNC case. And then the second question presented was that Title II of the Civil Rights Act bans race-based admissions that, if done by a public university, would violate the Equal Protection Clause. That's the principle that comes out of Gratz. And so the question was, is Harvard violating Title VI by penalizing Asian American applicants engaging in racial balancing, overemphasizing race, and rejecting workable race-neutral alternatives? So this case was decided June 29th. The slip opinion is 237 pages. We will not talk about all 237 pages today, thank goodness. But there's lots in here to unpack. So just a little bit of background for the case itself, the Harvard admissions process. So the Harvard admissions application asked students to provide student information, family information, SAT scores, and essays. Harvard permitted students to identify their race, but they did not require it. And the process, so an application was reviewed by a first reader who assigned scores based on academic, extracurricular, athletic, school support, personal, and overall categories. And race could be taken into account for the overall score. Then at the subcommittee and full committee level, the goal was to make sure that Harvard did not have a dramatic drop-off in minority admissions. Finally, Harvard created what they called a LOP list. Students who were being considered to not be admitted would be on this list. And this list had 4 pieces of information about every applicant: legacy status, recruited athlete status, financial aid eligibility, and race. So as we just mentioned earlier, SFFA argued that Harvard discriminated against Asian American applicants by assigning lower personal and overall ratings to Asian American applicants as compared to applicants of other races. In response, Harvard maintained that classroom diversity was essential to achieving its educational mission. In the UNC case, so UNC's admissions process, at UNC, every application was initially reviewed by one of approximately 40 admissions officers. These readers were required to consider race and ethnicity as one factor in their review. They also considered academic performance and rigor, standardized testing results, extracurricular involvement, essay quality, personal factors, and student background. The readers provided numerical ratings for the academic, extracurricular, personal, and essay categories. And then after assessing an applicant's materials, the reader would formulate an opinion about whether the student should be offered admission and would then write a comment defending his or her recommended decision. In this process, race could be a plus for an applicant. And following this first read process, the applications would go to a process called school group review. The committee would review every initial decision, and they would consider many factors. They could consider the applicant's race, and then they would make the final decision. So the legal framework for the Supreme Court's decision, first, everybody knows we have the 14th Amendment of the Constitution. This was at issue in the UNC case. 14th Amendment provides that no state shall deny to any person the equal protection of the laws. This is known as the Equal Protection Clause. And the core purpose of the Equal Protection Clause, as the Supreme Court has said in multiple decisions, is doing away with all governmentally imposed discrimination based on race. In the Harvard case, it was Title VI. So Title VI provides that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So most institutions, including Harvard and UNC, would receive federal financial assistance, and they would be subject to Title VI. UNC would also be bound by the Equal Protection Clause because it is a state entity. So both the statute and the Constitution were at issue. So again, I think as everybody knows, the court in this case held that Harvard's and UNC's admissions programs violated the Equal Protection Clause of the 14th Amendment. It was a 6-3 decision. The majority opinion was written by Chief Justice Roberts. He was joined by Justices Alito, Thomas, Gorsuch, Kavanaugh, and Barrett. There were 3 concurring opinions. Justices Thomas, Gorsuch, and Kavanaugh wrote those 3 concurring opinions. Justice Thomas also joined in Justice Gorsuch's concurring opinion. And then Justices Kagan, Sotomayor, and Jackson dissented. Justice Sotomayor wrote a dissenting opinion, which was joined by Justices Kagan and Jackson. And then Justice Jackson filed a dissenting opinion in the UNC case, which was joined by Justices Kagan and Sotomayor. So the majority's decision reiterated the Equal Protection Clause's core purpose to eliminate all governmentally imposed discrimination based on race. The majority said that this applies without regard to any differences of race, color, or national origin, and is universal in its application. Therefore, the exceptions to the Equal Protection Clause's guarantee must survive what the court termed a daunting 2-step examination, which is called strict scrutiny. And in this context, it consisted of 2 questions. Is the racial classification used to further a compelling governmental interest? And is the government's use of race narrowly tailored, or in other words, necessary to achieve that compelling governmental interest? In the context of college admissions, the majority cited Bakke and Grutter to define the narrow confines for the use of race. So, as Stephanie mentioned, Bakke found that obtaining the educational benefits that flow from a racially diverse student body was a compelling interest, but racial and ethnic distinctions of any sort are inherently suspect. The Bakke justices also indicated that race can be considered in admissions to remedy the effects of past societal discrimination. In Grutter, the Grutter court endorsed the view that student body diversity is a compelling state interest that can justify the use of race in university admissions, but Grutter placed limits on the use of race, including prohibiting quotas, and these limits were put in place so that the use of race would not devolve into illegitimate stereotyping and could not occur in a manner that unduly harmed non-minority applicants. Also, as Stephanie mentioned, Grutter indicated that at some point, race-based admissions programs must end. So from these prior cases, the majority defined the limits on the use of race as follows. The use must comply with strict scrutiny. Race cannot be used as a stereotype or a negative, and the use of race must, at some point, end. So the majority found that the UNC and Harvard admissions systems failed each of these criteria. And I'll note here that the majority did not address Title VI in detail. Justice Gorsuch, who wrote a concurring opinion, would construe Title VI more strictly than the Equal Protection Clause. Essentially, he said that liability under Title VI is strict liability. It would not matter if there was a compelling interest or the means were narrowly tailored. You just can't do it under Title VI. So as we talked about, Title VI applies to recipients of federal funds. And so that would certainly reach more universities than the Equal Protection Clause would on its own. Also, note too that the court did not outright prohibit affirmative action in college admissions, but the test that it set forth and its reasoning, I think, will make it very hard to use affirmative action going forward. So the majority's analysis, Harvard and UNC programs failed the test that the court set forth. First, they failed the strict scrutiny test. Justice Roberts said that the governmental interests that the colleges put forth were not sufficiently measurable to permit judicial review under the strict scrutiny rubric. So these interests included training future leaders, acquiring new knowledge based on diverse outlooks. There were many others. And he said these were commendable, but they were not sufficiently coherent. He also questioned how the courts were supposed to measure these goals, or if they could even be measured to know when these goals were achieved. The court said that there was no articulation of a meaningful connection between the means employed and the goals sought to be achieved. In particular, the majority took issue with the racial categories used by the colleges and said that they were overbroad, arbitrary, and undefined, and under-inclusive. The court also found that the admissions programs at issue used race as a stereotype or a negative. The majority relied on the proposition that admissions in higher education are a zero-sum game. A benefit provided to some, but not to others, necessarily advantages the former at the expense of the latter. Also, they found that these programs required stereotyping. The majority reasoned that if colleges admit students on the basis of race, they are assuming that all students of a particular race think alike because of their race. Then finally, the court found that the admissions programs did not have logical endpoints. So Harvard and UNC argued that their programs did have logical endpoints, of course, that they would end when meaningful representation and diversity on their campuses was achieved. They also argued that the programs would end when students received the educational benefits of diversity. And the court rejected these arguments. The majority viewed the first argument as racial balancing because colleges would have to compare the racial breakdown of an incoming class to some other metric, such as the previous class or the population in general, in order to determine if meaningful representation and diversity had been achieved. And then as to the second argument, the majority said that it did not know how to determine when or if the goal of receiving the educational benefits of diversity had been met, and rejected the argument that periodic review by the colleges themselves would serve as a proxy for identifying a specific endpoint or date for the program. So as I mentioned before, we had 3 justices dissenting, and the dissent, in contrast to the majority, would have found that the student body diversity is a compelling interest grounded not only in the court's Equal Protection Clause jurisprudence, but also in the First Amendment principle of academic freedom. The dissenting justices also would have found that narrow tailoring had been satisfied. The dissenting opinion stated that narrow tailoring does not mean perfect tailoring, and a college does not have to exhaust every conceivable race-neutral alternative in order to show that race-conscious means is narrowly tailored. The dissent also reiterated that the court's prior precedent reflected the constitutional necessity of racially integrated schools in light of the harm inflicted by segregation and the importance of education to our democratic society, so hearkening back to Brown. And the dissent said, in essence, that the limited use of race under the prior precedents of the court had helped to equalize educational opportunities and also has improved racial diversity. And these 2 achievements advances the Constitution's guarantee of equality and promotes Brown's vision of a nation with more inclusive schools. The dissent viewed the majority's opinion as rendering strict scrutiny fatal in fact, because in the dissent's view, it set parameters that no college or university could satisfy. The dissent also disputed the majority's holding that indifference to race is the only constitutionally permissible means to achieve racial equality in college admissions. They found that that was contrary to precedent and the teachings of history. They took issue with the majority's discussion of a colorblind constitution. In particular, Justice Jackson said that deeming race irrelevant in law does not make race irrelevant in life. And Justice Sotomayor said the majority decision cements a superficial rule of colorblindness as a constitutional principle in an endemically segregated society where race has always mattered and continues to matter. And of course, hearkening back to other monumental cases coming out of this court, the dissent criticized the majority for failing to grapple with the extraordinary showing required by stare decisis in its overturning of these affirmative action precedents.
All right.
Oh, you want to do it, Aaron?
No, well, I'm, one of my few important critical roles, the secret words. Sure. So today's second secret word is university. How very clever of us that these all somehow relate to the presentation topic. So if you have a moment, please, and particularly if you're interested in CLE, please click on the appropriate tab next to the word university so that we can make sure that you are getting all the credit that you deserve. And Katie, thank you so much for that overview. I'll just, while folks are clicking on the correct button here, so we're about to transition to our last section, which is a little more of a Q&A, and I'm going to ask some questions of Stephanie and Katie. But I also wanted to encourage folks who are listening in, we're private practice attorneys. We work with a number of colleges and universities and had a lot of conversations since this decision just about what folks are doing and how they're managing. We're going to talk a little bit about that. But, we certainly appreciate that the folks on the line are actually at institutions and having conversations and have to contend with operationalizing and sort of implementing these decisions. And so I will invite you, while we are chatting here over the next few minutes, if you would like to include in the QA section, certainly a question, but if you are amenable and would like to provide any just feedback or observations regarding how your institution may be reacting to and contending with the decision. Would love to see that, and if it pops up and we have time, we'll try to share a little bit. And so in addition to sort of offering our perspective during this next segment, maybe at the end we can share with all those who are on the line the perspectives of other schools who are trying to figure this out, to the extent that we have some time to do that. Okay, so hopefully you have clicked on university. And now we're going to move on to our last section, impact and future considerations. Our first question, which seems like a no-brainer, but there's more to it than meets the eye. How does the decision impact today's college admissions landscape? So, Katie, I'm going to start and ask you to answer this first, but the slant I'd be grateful if you could sort of consider and respond to. Many folks are not attorneys, and many of us who are attorneys aren't Supreme Court attorneys or litigators. And so there's always this question when you get a decision, I think, at least for me, is how sticky is this thing, right? I mean, we know it's out there, but will it be appealed? Is there a place to appeal it? Will it be overturned soon? Are there 10 more cases in the pipeline? Will there be split decisions among circuits? So, there's always this ambiguity for me about what does this really mean, practically speaking. Is it sticky? Are we going to have to contend with it? Sort of understanding that litigation and all those things can move in a lot of different ways. So taking into account the decision itself, but then looking forward, how sticky is this thing? And should schools really be, is it going to change tomorrow or the next day, or is it here for a while? What do you think?
There are a lot of questions in there, Aaron.
I know. See, it looks like one question, but it's actually 20.
It's a lot of questions. We all have a lot of questions. So your question about it being sticky. Yes, I think in many respects, this decision we could describe as very sticky. It is a decision of the Supreme Court. There is no further appeal. And it is a decision that has been rendered by a majority on the court that is relatively new, relatively young, considering the general age of Supreme Court justices. So they're lifetime appointees. So they're going to be there a long time, and I think it's very unlikely that that if they got another case that was very similar to this case, if they even, granted review of a similar case, that we would have a different outcome. And, we know what the decision says. And I think, we know what its narrow impact is, which, I would say is that it's going to be very hard for institutions to craft race-conscious admissions policies that meet the Supreme Court's very strict requirements now. And the decision applies today. The court did not give institutions a grace period to figure out what they were going to do next, to, turn their admissions policies around. And so as educational institutions, it's really important to, take the decision seriously, look at your admissions policies and make the changes that you need to make to be in compliance with the Supreme Court's decision.
Yeah, can I actually?
Yeah,
it's okay. We just got a question. Let me jump on what you just said there. So someone has asked, how does the decision impact classes incoming this fall? For those of you on the line who are in higher ed, of course, many of you have already made your admissions decisions for your incoming fall classes. I mean, I suppose you may have some late decisions being made or adjustments, based on what your students are deciding to do. But it's fair to say that admission cycle is always sort of running to some extent, right? You do have those adjustments that may impact incoming fall classes. You've got folks who may be applying right now to start next spring or for a winter term. So there are decisions that are being made right now. And I guess following up on what you said a minute ago, I mean, is it fair to say that as of the day this decision was made, admissions departments in real time had an obligation to start to make decisions in accordance with the Supreme Court doctrine? In other words, they got to pivot right away, right? I mean, is that fair? Because to your point, you said there's no grace period here.
Yeah, I think, and that's, a lot of very, very smart people have read this decision. And, it's lots of them have said, the Supreme Court didn't give any wiggle room here. And how that looks in practice, I don't envy the admissions departments at these institutions for having to, kind of turn on the head of a pin and really, give their policies a hard look and make these changes quickly. But yeah, I think that's it. It does. It applies right away, and so it needs to be attended to right away. Sure.
Yeah, certainly on a go-forward basis. I mean, I've seen, a number of people have asked about the implications of the decision outside the admissions process. I know we're going to get to that in a minute for the folks who are asking those questions, and particularly with regard to scholarship and financial aid considerations. And the reason I bring that up in part is because, I've also seen a fair amount of press in some schools and even the state of Missouri, which we'll talk about in a few minutes, where financial aid, for example, has already been awarded for folks who are incoming this fall, and where admissions decisions were made prior to the court's ruling, and admission was already offered. I mean, Katie, you tell me if you disagree, but my sense is that there is a general agreement that institutions, there's no obligation to go back and, start rescinding admissions decisions that were made prior to the court's decision, or altering financial aid or scholarship decisions that were made prior to the decision. But insofar as those decisions are made after the date of that decision, I think the court's decision has to be taken into consideration. Would you say that's a fair sort of fair landing as far as where the landscape is right now?
Yeah, no, I think that's very fair. And unfortunately, it puts institutions in a sticky position, especially the institutions that are kind of in the middle of those admissions processes. And so, how institutions figure that out, it's a case-by-case basis. And they certainly should, work with their counsel to figure out the best way to take into account the Supreme Court decision moving forward.
There is a disclaimer at the end of this presentation, so that was not legal advice. That was a general reflection on where things are right now. By the way, Katie, so I've derailed you a little bit, maybe to get you back into the conversation you're already having. And to this point, the court's decision has come down. there's some other stuff presumably in the pipeline. There may be lower court decisions that expound or offer distinctions here in different circuits. You could have states taking positions. Is that all fair? I mean, over the coming months?
Yeah. And I think, we'll talk about it a little more in a minute, just kind of the all the places where I think institutions should be looking for kind of how this decision is going to play out. Because again, it's a decision that is based on 2 colleges' admissions policies. It's specifically in the context of higher ed admissions, but certainly that doesn't mean that we can ignore it for everything else, right? Or we should ignore it for everything else, unless, there will be a lot of litigation, and there will be, I think there will be certainly guidance coming out from agencies, and so institutions will have a lot of stuff to continue to monitor as this plays out.
But we were talking about this yesterday, and I'll just share with the group online here. For those of you who have been dealing and listening into our other presentations, in higher ed, there's been a lot of regulatory whiplash over the last 8 years at the agency level, right? As one administration comes and another goes. And, the U.S. Department of Ed is just totally rewriting its regulations every 2 to 3 years, which I know has led a lot of institutions, at least in my experience, to sort of say, well, how much time should we invest building an infrastructure to comply with this version of this rule when 2 or 3 years later, our financial responsibility or bar defense or Title IX or gainful employment or, you name it, is going to be different. And here, one of the things we just wanted to emphasize in the presentation is, while we think there will be a lot of clarification from agencies, maybe adoption from agencies, interpretation from the White House, all those kinds of things, and states, and et cetera, we don't anticipate a Supreme Court decision in a different direction anytime soon. We think the stickiness of this fundamental position is significant, and more significant than what you may have been experiencing in the regulatory setting, when dealing with the U.S. Department of Education. So it's worth taking the time to figure out how to contend with this ruling for years to come. Subject to those modifications and interpretations that we may see in specific circuits or, out of the White House or the U.S. Department of Education, et cetera. Katie, is that a fair summation of our...
Yeah.
Okay.
Definitely. And I wanted to mention that, one interesting piece, maybe it was just a footnote, I think, in the decision. And this is potentially a case that, could at some point make its way to the Supreme Court, is that the court in the Harvard and UNC decision specifically carved out military institutions from its ruling. Right. And so this was in response to a U.S. amicus brief. There were other amici that weighed in specific to military academies. And the U.S. had argued that race-conscious admissions programs furthered a compelling interest in national security. And so in the majority opinion, Chief Justice Roberts cited the potentially distinct interests that military academies may present and said this, military academies are excluded from our decision here today. So I think one question. And it's, I think already SFFA is seeking out students who have been denied admission to military academies. So I don't think they're going to let that exemption lie too long.
So Stephanie, taking a slightly different angle on this question, we were talking about earlier, and would love if you could talk a little bit about, this doesn't affect all schools in the same way, right? As a consequence of some of how those schools function and their admissions policies, and there are certain states that already have certain laws on the book. So could you, I'd be really grateful if you could tell us a little bit about how the decision may or may not impact the higher ed landscape sort of in that regard.
Yeah, absolutely. So as of right now, there are or have been 9 states that have prohibited the use of race in admissions. And in looking at those states, there are certainly takeaways that can be drawn, from those admissions policies that are in place in those states. But I guess generally speaking, if you're a school that's in one of those states, this decision is going to affect you very differently because you probably are already considering alternatives or have had to have those alternatives in place for a long time. Some states like California, this prohibition went into effect in 1996. So, those state institutions of higher education have needed to use race-neutral policies in their admissions programs for now many years. So, I think, though, in looking at those states and looking at that information, those experiences of the schools there can help guide what colleges in other states or, private institutions may be doing going forward.
And we actually have someone who's asked, and this is a great sort of follow-up, for institutions with open enrollment or non-competitive enrollment, this may not have much impact, right? Because by definition, they don't have an admissions policy, no matter what state you're in. They don't have an admissions policy that is drawing distinctions based on race, presumably, if they're open enrollment. Is that fair too?
Yeah, exactly. That's fair. If you're already implementing, race-neutral policies in your admissions and enrollment procedures, then I think that's completely fair in that this decision doesn't have, the same impact of needing to change everything immediately and now. So yeah, absolutely.
With that, that's a good segue, as they say, to our next question. And Stephanie, I'll start with you, and then I'll ask Katie your opinion on this too. So we know that there are some schools that are in states where this is already race-based admissions policies that take into account race as a factor are already prohibited. We know there are some schools, like we just said, with open enrollment or non-competitive policies that may not be impacted, but there certainly are many that are. And for those institutions that have admissions-based policies right now that take into race as a criterion that are implicated by these decisions, what are alternatives they might employ to advance their diversity goals nonetheless? Because many of them, we know in higher education, I'll just say most schools have stated diversity goals for their class, for the composition of their classes. So what are some alternative methods that we've seen maybe out of those states where race-based data points have already been prohibited? What are other things we're reading about or seeing schools doing?
Yeah, sure. So I think most simply almost is that we're seeing that there is an expansion of targeted recruitment. So this is an increase in recruitment efforts in areas where there may be greater racial diversity. Though I think that there is some considerations there that need to be taken into account of, while expanding that targeted recruitment to regions or areas could be looked at as a race neutral approach to recruitment. There are already some challenges popping up that this targeted recruitment could actually have a race-based focus, which then may not actually be following what the decision is telling us. So, while we have seen that increase in that targeted recruitment, also just recognizing that does still need to be applied race neutrally across the board.
So, in other words,
sorry.
So I was just going to say, so if you've got a plan where you are, instead of using race as a data point, you are focusing on socioeconomic diversity or geographic diversity and things of that nature. On the one sense, those may be very good ways to promote diversity in your class that aren't explicitly tied to race. But it sounds like what you're saying is, but you still have to be careful, because if they are functionally serving as a proxy for race, particularly in a way that is easily demonstrated, you could be back to having a problem.
Yeah,
so it's a tricky
exactly.
dance. Yeah.
Exactly right, and I think that your point about the class-based and or looking at first-generation students, other kind of race-neutral criteria is a good one, because schools are doing that already, and there have seen some mixed results in terms of how that actually does increase diversity on campuses, but it is a race neutral way of looking at admissions and admissions policies. Along those lines too, we've seen that some schools have developed what's called an adversity scale. So assigning points basically based on different factors that make based on the adversity that a specific student may have faced, and then that is creating a number. And when that adversity scale is implemented, it actually has really increased diversity on campus. But Aaron, similar to what you just said, that too could have some, kind of sticky pieces there of, well, what if race specifically is one of those factors, and looking at that as well. Then also looking other things that have been considered are the idea of percent plans. So with that, institution would accept, say, the top 10% of every school or public school within a state. That has been done already in California, Florida, and Texas. And it is, going to provide automatic admissions to students that are in that top percentage of their graduating class. And that really has, in some areas, that has been a way to increase diversity on campuses, because it really is a race neutral approach, but it is, since it's taking from every school within a certain region or state, you are going to get a diverse population. It's not true everywhere. There's a lot of factors that go into that as well, but it is one of the things that is being looked at and considered and implemented when looking at other ways to enhance diversity on campuses.
Yeah. So maybe ironically, my understanding is that the percentage plans are most effective in states where you have fairly segregated housing or living circumstances, right? Because if you're taking the top 10% of every single high school, then that means in those areas where you have a large percentage of certain minority populations, theoretically, you ought to be getting 10% of the students from there who represent those minority populations. But in a state, in theory, that is, theoretically, if throughout the entire state the housing was all a perfect representation of the overall demographics, you wouldn't get that same result. So it's interesting that the percentage plan, in theory, works best where you actually have segregated living, which is sort of interesting. Katie, additional thoughts on this question? I know we're down about 7 minutes, but wanted to be sure to get in there, and I want to get to this last question too, for sure.
Yeah, so I'll talk fast here. So other things that we're already seeing, schools increasing need-based financial aid. So Duke, for example, beginning with the 2023 fall semester, is providing full tuition grants for undergrads admitted to Duke from North Carolina and South Carolina, whose family incomes are $150,000 or less. For these same students who have family incomes less than $65,000, they will add in aid for financial assistance for housing, meals, course materials, campus expenses, to make it even more possible that these students can afford to go to Duke. So that's one way, or one more way, one tool in the kit. Increasing recruitment and admissions from community college transfers as well. This is something that has been talked about, and I think it's it's another way to get at another population of students that really they've you want them to come to the four-year colleges, and you're recruiting from a base of students that has already proved to to be interested in higher education, and so that's another tool. And then going back to the decision, and I'll just touch quickly on this a little bit. Chief Justice Roberts, at the end of his majority opinion, he said, of course, this decision doesn't prohibit universities from considering an applicant's discussion of how race has affected their life. This is hard to implement in process, right? So you have to, maybe you can consider race if it's connected to the student's personal attributes, individual experiences. Those experiences are connected to the institution's mission, to the type of students that the institution wants to attract. Seems like a really hard thing to do in practice. It may raise more questions than answers. Certainly for me, it does. And it's open to legal challenge as a proxy for race, especially given Chief Justice Roberts' discussion of how colleges can and cannot use discussions of race in application essays. So,
and Katie, am I right? One of the dissenters sort of called that out, right, and took the view that this was not really a distinction that could be put into practice. Am I remembering that correctly, or am I making that up?
No, I think you're remembering that correctly. And also, Robert says, they talk to each other in these opinions, which is disconcerting. Yeah. But Robert said, well, don't look to the dissent for what you're supposed to do going forward. So I think there's certainly a big question about kind of how this works and if it works in practice.
So I'll just recap quickly, and then we'll hit this last question. And we're going to stick around after the top of the hour, folks, for at least a few minutes. So I don't want you to think we're just going to automatically shut off here in 3 minutes. But just a recap. So you've got the percentage plan approach, like we've seen, for example, down in Texas, where you're just taking 10%, the top 10% of performers from every high school across the state, automatically get admitted, and that's for public university system down there. And we talked about sort of the pros and cons of that. You've got the trying to increase community college transfer relationships, and those are both admissions-based approaches, as would be trying to craft a more holistic review of race-based experience as opposed to race itself as a criterion, or trying to build in criterion that are socioeconomic or geographic instead of based on race, with the notion that those would still promote sort of a level of diversity within the class. And as both Stephanie and Katie noted, we know that there are institutions, particularly in those states where race-conscious admissions has already been prohibited, that have been trying out some of these concepts. I noted that those are sort of admissions ideas, as would be moving away from the use of standardized tests or GPA or sort of those traditional metrics that some have criticized as being implicitly biased. But what's interesting to me is the Duke plan is really a financial aid focused plan. And I just highlight that to say that, there are some solutions that are focused on modifying the admissions criterion at the institution. And then there are other solutions that are focused on financial aid planning in a way that is intended to promote diversity. And of course, they're not mutually exclusive. You could do one or both. But there are a lot of things that are being done out there and that have sort of been piloted already in some of these 9 states. And of course, that are being discussed widely right now, I think, in higher education circles. So with that having been said, I'll just take us to our last question. We had several people ask what I consider a variation on this, and in particular with a focus on financial aid. So, Katie, I think maybe you could lead us off. And in particular, I'd be grateful if you could talk about what you think about the impact of this on other programs. Someone also asked about recruiting. Does this put limitations on your recruiting policies as opposed to admissions policies? We've got a lot of people who've asked about, your scholarships and other financial aid policies, et cetera. What do you think?
So I think it's all possible, which doesn't give you much guidance, right? But, you know, again, we talked about how the case itself is about higher ed admissions practices at these two schools. But that doesn't mean that we won't see the reasoning of the decision bleed into other areas in the education space. So, you know, beyond admissions and also kind of beyond education. So, you know, obviously we need to keep an eye on the legal challenges that are going to pop up, and use the Supreme Court decision as kind of their base for making their challenges to practices and programs. Watch the lower court decisions in your circuit. And we've got a couple of like interesting things that are happening right now. I think most people have probably heard about a complaint filed at the Department of Education regarding Harvard's legacy and donor admissions. So the complaint alleges that Harvard's legacy and donor admissions policies violate Title VI, and they're, you know, specifically referencing this case, the majority's zero-sum game rationale. And so we may see universities address legacy and donor admissions practices proactively. Wesleyan University just announced that they would end their legacy admissions. Beyond higher ed, race-neutral admissions policies at high schools are being challenged. Again, this one's unfolding in my backyard, so I find it super interesting. But a coalition has challenged the admission policy for Thomas Jefferson, which is one of Virginia's governor schools, highly selective magnet school in Northern Virginia. And so even though it's a race-neutral policy, you know, we're not talking about the very same test that the Supreme Court set forth in the Harvard and UNC decisions. This case has been decided by the Fourth Circuit, and I think in August we will see a petition for cert, and so it'll be really interesting to see if the court takes this case and tells us, you know, what it thinks about even like race-neutral policies. And I know folks had talked about, you had mentioned Aaron scholarship programs. I think, Stephanie, do you have anything to say on that front?
Yeah, Katie, I think that this area is really interesting. I think it's interesting because it really is a specific thing that is outside admissions that we are already seeing changes happen. You know, I'm here in St. Louis, and in Missouri, the Attorney General ordered that all state higher education institutions had to end financial aid scholarships or scholarships that take race into account. You know, that has already gone into effect here. You know, other states have also signaled that they're considering these things as well, and considering how the decision may apply to, you know, scholarships. But, you know, there's lots of people out there that have explicitly stated that it doesn't apply to scholarships, and that the opinion cannot be applied in that context, and because of the holding really only addressing admissions. So, you know, it is an area that I think is likely going to be challenged, and we may have to see how that all plays out.
And I'll jump in and just say, and I know we're over time, but my advice would be to schools. You know, litigation takes time. Agency actions can be very quick. And so, you know, you've seen, for example, here in Missouri, you had the government say, well, we're interpreting this in a certain way, and our interpretation is that it also applies to scholarship programs. And so institutions under our control, they have to do X right away, right, that are part of the state. And then those institutions ostensibly could push back if they wanted to. Somebody might challenge that in litigation. But the agency, or in this case, the state government, is able to act quickly to advance its opinion. The federal government can do the same thing. I mean, if you take, for example, Title IX, you know, we had a Supreme Court decision, I think it's about 4 years ago now, under Title VII, that interpreted sex discrimination to include discrimination based on gender, sexual orientation, sexual identity, et cetera. The administration at that point in time or actually it was this administration, a year after that decision came out, said, well, we also interpret this as, the Supreme Court was very clear. They said, well, this is just about Title VII. We're not saying anything about this extending beyond that. But the federal government, which liked that decision, this administration, which liked that decision, said, okay, the U.S. Department of Education said, well, we're going to interpret this also to apply to Title IX. And so on a go-forward basis, when we enforce Title IX, our definition of sex discrimination is being consistent with the Supreme Court's decision, even though the Supreme Court's decision was, per the Supreme Court, isolated to Title VII, right? And I just highlight that to say, I don't see this administration taking this Supreme Court decision saying, well, we're going to run with this and expand it. But a subsequent administration might do that, right? If you got a Republican administration in the White House in a couple of years that felt strongly that this should be expanded, just like this department has done in expanding that Title VII decision to cover Title IX, you could see a subsequent Republican administration say, well, we're going to expand this decision into other areas. And I highlight that because it's something that can be done overnight, right? I mean, with an electronic announcement. So whereas that litigation can take a long time to sort of play through, and you get these complicated decisions with, you know, every justice writing their own opinion and joining other opinion, you know, an executive agency can issue an interpretation overnight, and it can impact the industry. So I encourage institutions, you know, keeping an eye on NACUA's website and other trade association websites for the status of litigation is, of course, very wise. But I also really encourage you to keep an eye out for communications out of your state agencies and potentially out of the federal government, and particularly a subsequent administration that might have an interest in expanding this interpretation into other areas. So we are almost 10 minutes over. This is an extraordinarily impactful and significant and complicated and interesting topic, which is we're hardly able to really scratch the surface in 60 minutes. We greatly appreciate you guys joining us and tuning in. I think we got at a lot of the questions that were asked actually through this conversation. So I'm going to go ahead and close this off here, but we really appreciate everybody listening in. We encourage you and wish you best in continuing to follow this and think about it and read it and understand it and in implementing it on your campuses. If you do have a minute, we're always grateful if you can fill out that post-webinar survey. Thanks to everybody. Hope you are well, and hope the rest of your summer is a good one. Bye all.